Hello and welcome to part 10 of our series of webinars building up to the opening of the Unified Patent Court and Unitary Patent. In the last webinar we discussed both the general duty to produce documentary evidence and also specific measures available in the UPC for gathering evidence, such as preservation and search orders. But because evidence is such a large and important aspect of UPC practice, we're following that webinar here with a discussion of the preparation of written evidence, in particular the evidence of experts. So this is, if you like, a kind of part B to part 9. We're also going to use this webinar to cover the related issues of experiments and provide an overview of how confidentiality of sensitive material is protected in the UPC, as well as the important right of parties to certain kinds of privilege protection. Now, just before I go on, a couple of housekeeping points. Please feel free to send us questions using the Q&A tab at the bottom right-hand side of the screen. We'll follow up as soon as possible after the webinar with proper answers for you. And just as soon as the webinar is finished, a little questionnaire pops up for you to give us feedback, and we'd be really grateful if you just very quickly fill that in for us, because it helps us improve webinars going forward. Now, for this webinar, for the purpose of this webinar, I'm joined by my Taylor Wessing colleagues Phillip Rektorschek, the salary partner in our Munich office, and Eelco Bergsma, a senior associate in our Eindhoven office. But before I hand over to Eelco to start the discussion, let me first update you on the latest developments with the court and the patent. Now, most of the focus since part 9 of our webinar series in March has been on the ratification of the UPC agreement in the UK and Germany and the precise steps that are needed to make this happen. This had been steadily progressing towards the proposed opening date for the court of the 1st of December. However, the UK general election is now bringing this into doubt. This election suspends legislative business in the UK for 7 weeks, meaning that the order implementing the protocol on privileges and immunities, which needs UK and Scottish parliamentary approval before ratification can take place, has now been held up. The risk is that this will not now be approved before the summer recess and political conference season. This seems to us to make it much more likely that the UK, followed by German ratification, would be held up until September. The consequence is a start date at the beginning of 2018 rather than the proposed December 2017. However, although the Conservatives under Mrs May are likely to be returned to office with probably a much increased majority, there is no suggestion that the government will actually change its mind about UPC ratification full stop. So the start of the provisional period is determined by different legislation which the British have signed, so whether this starts this month, as again had been proposed by the preparatory committee, depends on whether the full number of signatures or approvals from other contracting states have been collected. We're still waiting for news from the preparatory committee on what the status of this is. So as promised, I'm now going to hand over to Eelco in Eindhoven to introduce the subject of experts and witnesses of fact. Eelco.
Yes, thank you, Paul. Sorry, we're on slide. Yeah. All right. Decisions and orders on how and when expert evidence and/or witness statements of fact are to be based in UPC proceedings are mainly intended to be made by the judge rapporteur at the interim conference stage. That is, the hearing arranged after the pleadings in the case have been exchanged in the written procedure. At the interim conference, the judge rapporteur can issue orders on, among other matters, experts, party appointed and court appointed, the matters to be the subject of oral evidence, the scope of questions to be put to witnesses and experts, and the hearing of witnesses and/or experts before the panel at an oral hearing separate to the main oral hearing at the end of the first instance proceedings on the merits. Preparatory discussions with witnesses and experts to properly prepare for the oral hearing may also happen at the interim stage, about which we will say more below. Note, in particular, that the evidence of an expert and/or witness will be heard in person during the oral proceedings if this has been ordered by the court of its own motion or because the statement concerned has been challenged by the opposing party. Furthermore, if a party seeking evidence cannot obtain a written statement, they may apply to have the witness heard in person instead. Experts and witnesses who give evidence orally may also have questions put to them, about which we also say more below. Given the importance of expert and witness evidence to the court, there are a number of general and specific duties with which they must comply. To begin with, witnesses and experts must obey a summons to attend the oral hearing. Failure to appear, refusal to give evidence, or a refusal to make the declaration of truth that is required may result in a fine of up to 50,000 euros, together with a further summons at the witness's expense. However, there are narrow exceptions to the obligation to give oral evidence for witnesses who are related to a party to proceedings. A witness or expert may also refuse to answer questions that would violate a professional privilege or other duty of confidentiality under an applicable national law, or expose them or certain family members to criminal prosecution under an applicable national law. A witness or expert may also refuse to give evidence protected by litigation privileges, a subject which Paul discusses a little later. Note also that although the UPC is an international court without its own criminal sanctions, a witness or expert who gives false evidence may be reported to the authorities responsible for criminality in the contracting member state hosting the court in which the false evidence is given. There are also important specific duties applying to experts. In particular, in the UPC, experts may be instructed by one or other of the parties to the dispute, by contrast to appointment by the court. However, such a party-appointed expert is under an obligation to give evidence independently and impartially. They must not be partisan. To ensure this, and to protect experts themselves, the rules of procedure put in place duties designed to make the process of preparing such evidence transparent. In particular, there is an overriding duty of the experts to the court that he or she must be independent and impartial. In the case of party-appointed experts, this duty overrides any duty to the party instructing the expert. As regards court-appointed experts, the parties may also be heard on the expertise, independence, and impartiality of the court expert. The rules governing conflicts of interests that are applicable to the judges also apply by analogy to court experts. The court-appointed expert must also inform the court of their progress in writing their report and present the report in writing within the time period specified by the court order. A failure to do so within the time specified, or any agreed extension of time, may result in the court appointing another expert. The report must also cover only those matters that have been put to the expert. There is a further obligation on court-appointed experts not to communicate with one of the parties without the other party being present or without their consent to such a communication, and any communications must be documented in the expert's report. The expert must also not communicate the contents of the report to third parties. In addition to the general and specific duties applicable to witnesses and experts, there are also a number of formalities that must be observed in the written statement or written summary of the evidence to be given. Just to briefly cover what these are, the statement must of course be signed, but it must also include a statement of truth. That is, a statement by the witness that they are aware of their obligation to tell the truth. The witness must also state that they are aware of their liability under the applicable national law that I mentioned earlier in the event that this obligation is breached because the UPC has no supranational rules of perjury or contempt of its own. The witness statement or summary must also state any current or past relationship between the witness and the party submitting the statement and any actual or potential conflict of interest that may affect the witness's impartiality. If necessary, the statement or summary should also state the language in which the witness will give their oral evidence. I mentioned at the beginning that among other matters to be decided at the interim conference, the rules of procedure state that the court will, in the presence of the parties, hold preparatory discussions with witnesses and experts with a view to properly preparing for the oral hearing. The extent of such preparatory discussions with witnesses and experts that is intended at this stage is unclear, but it does not appear intended to be a preliminary taking of oral evidence as such. Instead, it would seem that this provides an opportunity for the court to identify the relevant areas in which evidence is needed. It may also provide the opportunity to establish whether there is broad agreement between experts on some issues. So, discussions at this interim stage appear to be only a case management step intended to assist the court to establish those matters to be the subject of oral evidence and the scope of questions to be put to the witnesses at the oral hearing. So when proceedings on the merits arrive at the oral hearing, what happens? Oral testimony naturally will begin with identification of the witness or expert. In a mirroring of the statement of truth in their statement, if there is one, the witness or expert is then asked by the presiding judge to make the following declaration. I solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. The witness or expert, if they have made a written statement, must also confirm the evidence in their statement rather than repeat it, although they may have the opportunity to elaborate on it. There are then two sources of possible questioning of the witness or expert. First, we have the questions from the judges of the panel, and second, the questions from the parties. There has been a lot of speculation about how this will be concluded and, in particular, the potential role of cross-examination. The rules state simply that the questioning by the parties is under the control of the presiding judge and that the presiding judge may prohibit any question which is not designed to adduce admissible evidence. The scope of matters outside the admissible evidence referred to is unclear, but appears intended to include matters protected by litigation privilege, matters on which the witness may refuse to give evidence according to the rules I mentioned above, as well as issues that have not been identified by the judge rapporteur or presiding judge for attention. As regards cross-examination techniques, the rules of procedure are silent. Therefore, while in theory the parties may cross-examine experts and witnesses, their opportunity to do so is likely to be limited to quite specific issues, and the simple time constraints on oral hearings in the UPC seem likely to frustrate any significant use of this method. The UPC is of course an international court, and a short note to add to the subject of oral evidence is that, with the consent of the court, the witness or expert may be heard in a language other than that of the proceedings. In these circumstances, simultaneous interpretation into the language of proceedings can be provided. So that is a general account of how experts and witnesses are used in the UPC and the duties they are under. Jan-Phillip is now going to look in more detail at some of the specific issues arises out of the role of the expert in particular. Jan-Phillip?
Thank you, Eelco. Well, let's look first at court-appointed experts, which Eelco mentioned a little earlier. One or more of these can be appointed by the court at its discretion at any time in order to provide expertise for specific technical or other aspects of the case. If the court wishes to do this, it must draw on an indicative list of experts kept for this purpose by the registrar. The chosen expert must then prepare a report and attend the oral hearing if requested by the court, and answer questions from the court and the parties in the fashion described before. Importantly, the UPC agreement states that the appointment of a court expert is without prejudice to the possibility for the parties to produce their own party-appointed expert evidence. Consideration will therefore need to be given by the court and the parties as to when an issue is covered by a court-appointed expert, when it is subject to the evidence of party-appointed experts only, or when it might be addressed by both. It remains to be seen when the court will consider it appropriate to take evidence from a court-appointed expert as opposed to, or in addition to, party experts. National approaches differ widely in this respect. For example, court-appointed experts are not unusual in German courts, but a rarity in the English patent court. One area where it is clear that the rules of procedures specifically envisage the use of a court-appointed expert is for the conduct of experiments, which will be come to. Although court experts are drawn from an indicative list, the parties may make suggestions about who the court expert should be, their technical or other background, and the questions that should be put to them. It is the court's responsibility to then provide the expert with all the information necessary that that expert needs to provide his advice. The formal appointment of the court expert is by an order specifying information that includes the evidence submitted by the parties in respect of the technical or other question that the court-appointed expert is to address, the questions put to the experts with the appropriate level of detail, including suggestions as to any experiments that it may be appropriate to carry out, and the time period in which the expert reports must be presented. The expert must receive a copy of the order and confirm in writing that he will present his report in the time specified. The court must agree a fee with the expert for the preparation of the report and attendance at the oral hearing. Any expert advice given to the court by court experts will be made available to the parties, giving them the opportunity to comment on it. In the UPC, there may be as many as 3 sources of technical advice to the court: the technical judge, court expert, and experts appointed by the parties. So a question arises as, what is the relationship between the advice given by a technical judge, where one is appointed, and that of the 2 kinds of experts? In the context of a panel of legal judges without technical backgrounds of their own, the technical judge can be expected to assist the panel to resolve conflicts between the evidence of the party-appointed experts. However, to what extent should the court reject the need for an expert opinion if it considers the expertise of its own technical judge as sufficient? This remains to be seen. but it is doubtful that the pool of technical judges available to the UPC will have the variety and depth of expertise necessary to substitute for appointed experts drawn from an academia or professional practice. The expert is normally asked to address at least the claims of a disputed patent, pieces of prior art, and the common general knowledge. Having been called to give his opinion, the expert must normally do so as if he is standing in the shoes of the objective and notional figure known as the man skilled in the art. Having adopted the role of the skilled person, there is a question regarding whether an expert may be permitted to give his opinion on the ultimate questions in an action that are matters of law rather than simply fact. Most importantly, whether a patent is obvious. In English law, the expert may give his opinion on such ultimate questions, but the court is not obliged to follow it. That applies either for Germany. A recurring difficulty for those appointing parties experts is also how closely the expert's knowledge and experience must match that of the skilled person. If an expert is found whose skills in reality are a close match for those of the skilled person, it follows that he will probably be someone with less professional impact and credibility than a leading academic. On the other hand, leading academics and experts of similar standing are open to the accusation that they are naturally inventive and too far removed from the skilled person. The latter we will inventive and so more liable to think a disputed invention obvious. The UPC judges will need to decide whether they think this balance is to be struck. In England and Wales, the court has said that it will take into account overqualification and that it does not matter whether an expert only approximates to the skilled person, providing they are good at explaining things. In Germany, there is usually no comparison between the expert's level of knowledge and the skilled person's. Rather than that, the expert's duty is to explain to the court how the skilled person would understand the issue in question. Let's turn to the subject of experiments now, which we have mentioned a couple of times and which follows on from the subject of court-appointed experts. Experiments may be conducted in the UPC to prove statements of fact. Whether an experiment is appropriate is a matter for the judge-rapporteur to decide either of its own motion or on a reasoned request by a party, subject to having heard the party's representations on the matter. A party who does want to request that an experiment is conducted must lodge their request as soon as practicable during the written or interim procedures. This request must give the reasons for carrying out the proposed experiments, including identifying the facts that it is intended the experiments will establish, describe the proposed experiments in detail, propose an expert to carry out the proposed experiment, and disclose any previous attempts to carry out similar experiments. Further to the request, the other parties to the proceedings will be invited to state whether they dispute the facts that the experiment is intended to prove. The other parties will also be invited to comment on the request, including the identity of the expert proposed and the description of the experiments. If the judge-rapporteur decides in order to experiment, the order must then specify the detail of the experiment, the expert or experts who will carry out the experiments as the court expert, and draw up the report on the experiments. It must also give the time period for carrying out the experiment and, when appropriate, the exact time and place where it is to be carried out. Where appropriate, the court may also order that the experiment is carried out in the presence of the parties and their own appointed experts. In any case, once the report on the experiments is produced to the court, the parties will again be invited to comment on it, either in writing or during the oral hearing. And the expert or experts who conducted the experiment may be summoned to the oral hearing. There may be practical and tactical issues raised by experiments in the UPC, if the national practice in countries such as England and Wales is a guide, as the rules of procedure suggest it may be. In particular, a request that the court order an experiment to prove a statement of fact does not prevent a party or its expert carrying out experiments of its own. However, the inference of the rules is that such experiments are not admissible without the sanction of the court. Furthermore, the request for an order to conduct experiments must disclose any experiment that the party has already conducted on their own account. Such experiments would otherwise be protected from production by litigation privilege, which Paul is coming to. Therefore, in practice, a party may not secretly rehearse an experiment or series of experiments prior to using it to prove a statement of fact in proceedings, so-called litigation chemistry, without having to waive privilege in the earlier attempts, including those that did not work, if they want to rely on the same or similar experiment in court. Experiments can therefore be expected to require very careful consideration in the UPC. I will now hand back to Paul.
Thank you very much, Philip. So, in our last webinar, we mentioned a number of times in the context of obtaining documentary evidence the subject of confidentiality protection of sensitive commercial material. This is actually a general issue relevant to all evidence, and so I want to turn to it in a little more detail now, and then I'm going to go on to talk about the related subject of privilege. So the UPC operates according to the principle of open justice, in which proceedings are, by default, open to the public. This principle is explicit in the rules of procedure for the interim conference and the oral hearing. Furthermore, written pleadings, written evidence, decisions and orders lodged at or made by the court and recorded by the registry must, again, by default, be made available to the public under the general scheme of the rules. However, the court can decide to hear a matter confidentially, including the interim conference and oral hearing. It will do this to the extent necessary when it considers that it's in the interest of one of the parties or other affected persons, or in the general interest of justice or public order. However, as with so many things with the UPC, the court's approach to these issues will be a matter for the judges to develop in case law, and there is no guidance beyond the rules on the issue at the moment. Also, as Eelco mentioned earlier, experts and witnesses, fact, may refuse to answer questions if to do so would breach professional privilege or duty of confidentiality imposed by the national law applicable to them. Confidential material in documents may also be protected, as may decisions of the court, presumably by way of redaction of the sensitive information in question. This rather begs the question of what confidential information actually is. The starting point for answering this question is Article 58 of the UPC agreement, which is concerned with the protection of confidential information. It begins by defining such information as trade secrets, personal data, or other confidential information of a party or of a third party. So confidential information is not apparently restricted to any definition of industrial trade secrets, as may be found in national law or indeed the upcoming Trade Secrets Directive, but it extends to other information which can justifiably be considered confidential in nature. Although this would inevitably seem to raise further questions about whether a document is confidential if it's regarded as such under the laws of one contracting member state or other countries, but not others, another matter the court must deal with. There is a process for protecting confidential information. Parties to proceedings have the right to request that information which is in issue in proceedings is kept confidential from the public if they can provide specific reasons for that confidentiality. Where the request is to keep parts of written pleadings or written evidence confidential, copies of the documents concerned must be provided in the request with the relevant parts redacted. If this request has been made, the registrar then must ensure that the information concerned is not made available until such time, that is, as an application is made by a member of the public that they should have access to that redacted material, which I'll come to in a moment. In order to protect the confidential information of a party to proceedings in the UPC or of a third party, the court may also order that the collection and use of evidence is restricted or prohibited, or the court can order that access to this evidence is restricted to specific persons. As a result, it appears that confidentiality clubs, so-called, which is an English expression, in which disclosed information is restricted to certain named individuals agreed by the parties on their own terms, may be endorsed by the court, or in circumstances where there is no agreement, the court may even impose them. As I mentioned, however, members of the public are entitled to lodge an application with the court for an order that any information that has been excluded from public access is made available to them, so long as they provide grounds why they believe the reasons for confidentiality should not be accepted and the purpose for which the information is needed. In these circumstances, the court will invite written comments from the parties before it makes any order. The rules then say that such an application should be allowed unless there are legitimate reasons for given for maintaining confidentiality that clearly outweigh the interests of the applicant in gaining access to it. Again, the court has addressed situations of this kind, until the court has addressed situations of this kind, we're in the dark as to how exactly it will guide itself and what these legitimate reasons might be and how this balance is to be struck. But we would submit that it's serving the interests of justice that should again be at the heart of that kind of decision. So turning to privilege, the rules of procedure of the UPC also contain a number of provisions protecting the privilege of the parties to a dispute. Now, privilege is a general expression familiar from English law, which covers two main concepts. First, attorney-client privilege, and second, litigation privilege. These are addressed to different circumstances, although they can overlap. Attorney-client privilege is the right to protect advice sought by a client from their lawyer or patent attorney from disclosure in UPC proceedings. The advice is protected by privilege in the sense that it prevents a lawyer or patent attorney and his client from having to disclose or be questioned or examined about that privileged material. So unlike confidential information, which may be protected but at the same time can be reviewed as evidence by the court, privilege is an absolute protection against revealing information to the court. It is therefore a very important right. Nonetheless, there is a relationship between confidentiality and privilege, which is this. Whilst information does not have to be privileged to be confidential, for advice to be protected by attorney-client privilege or litigation privilege, it does have to remain confidential. This means that privilege will be waived and the protection lost by a voluntary disclosure of the protected material by the client. Just a note on the expressions lawyer and patent attorney here, because these are specifically defined for the purpose of the privilege rules. A lawyer is not limited to a representative authorised to practice before the UPC, but includes any person who is qualified to practice as a lawyer and to give legal advice under the law of the state where they practice. A patent attorney is a person who is recognised as eligible to give advice under the law of the state where they practice concerning the prosecution or litigation of patents or patent applications. This includes a professional representative before the EPO. However, in English courts at least, privilege is a complex area, and in the UPC it can be expected that questions will arise from time to time about what is and what is not protected information, when it comes to gathering and preparing evidence. The breadth of meaning of advice, for example, and the use of agents employed by the client to seek and receive advice are obvious grey areas for the time being. So let's turn to litigation privilege. Litigation privilege is the other major category of privilege that applies in the UPC. It differs from client-attorney privilege in two main ways. Firstly, the protected communications must have been made to obtain information or evidence of any nature for the purpose of or for use in proceedings. In this sense, it is narrower than client-attorney privilege, but also litigation privilege protects not only communications between a client or a lawyer or patent attorney, it also protects communications with a third party. Client-attorney privilege doesn't do that. So in this sense, litigation privilege is broader than client-attorney privilege. Again, documents protected by litigation privilege are exempt from production in proceedings, and the client or their lawyer or patent attorney may not be questioned on them. Because it extends to third parties, litigation privilege protects the preparatory work of experts when producing evidence for UPC proceedings. However, as with client-attorney privilege, parties must be careful to maintain the confidentiality of privileged documents and communications. Even a partial disclosure of information may be deemed to have waived privilege in the document or a wider group of materials more generally. And again, national experience demonstrates that litigation privilege is a complex area, and questions will arise that the penalties of the UPC will, in due course, need to clarify. So as I said, privilege is not to be confused with confidentiality. A document can be confidential without being privileged, but the right to withhold production of a document on the grounds of privilege is lost once it ceases to be confidential. So once a client agrees, as I've said, without restrictions to privileged documents being produced to another party, the right to withhold production of the documents on the grounds of privilege is lost. Questions may arise in the UPC, for example, about whether a client can agree to produce privileged documents for a limited purpose only, and therefore whether the privilege is preserved for any purpose outside this limited production. Another important issue will also be how to ensure that documents which are accidentally produced to another party remain confidential and privileged. The proper approach we would suggest ought to be that such documents must be returned without being read. And determining whether production is accidental would be a matter of examining the relevant acts of production and putting them in their context. There's a related concept of common interest privilege in English practice, which, though not a substantive form of privilege of its own, describes the principle under which documents already protected by privilege may be shared by parties with a common interest without the right to protection from production. This might be relevant to a patentee and a licensee, for example. The essential idea behind common interest privilege is that the parties have a common interest in the production of the advice at issue. However, there is no such privilege expressly provided by the UPC agreement or rules of procedure, and it remains to be seen whether the panels of the UPC will recognise a shared privilege in matters of common interest of this kind. Then there's without prejudice privilege. Without prejudice privilege is different in kind to legal advice privilege and litigation privilege, as it doesn't protect communications between the lawyer and the client. Instead, it protects communications between parties to a dispute from being generally admissible in evidence if they're made for the purpose of a genuine attempt to resolve that dispute. This principle is founded on the public policy of encouraging the settlement of disputes, even though this may conflict with the policy of providing the court with the best evidence. Public policy also requires these negotiations to be protected from disclosure to third parties. Without prejudice, protection is provided in cases of attempted settlement in the UPC, and so this may be an important means for parties, lawyers, to communicate with each other with the intention of settling a dispute, without those communications being admissible in court. So, that concludes our webinar today, and as I think is clear, the subject of evidence, perhaps more than any other area of the UPC, raises questions, and we've tried in this webinar to take a realistic approach to those based on what we know of the approach of the national courts, but clearly the detail will obviously come only when the UPC starts making its decisions. We'll wait and see. As I say, please wait a moment and fill out our feedback form, and I hope you will join us for our next webinar on the 20th of July, when we'll be discussing languages in the UPC. Until then, goodbye.